but unfortunately, due to time mistake, my name is not accurate.
Yeah, for correction.
Lord, may I seek your lordship leave to mention a matter? Lord, an arbitration proceedings had been referred before this honorable court. Lord, the matter was subsequently taken up for hearing and the matter was disposed of. My lord, the original agreement, partnership agreement, forms a part of the case record. For return of that original agreement, my lord, I am mentioning this matter.
Yes, but you have to make a formal application.
Ma'am,
Make a 2-page application, we'll list it, we'll return it.
ma'am, my lord, I shall make the application.
Please. Call the list, please.
Number 1.
Yes,
Praying for short pass off.
Half of the state, I'm ready with the system.
Yes.
we can't do it this way. There are no passovers in this courtroom.
Short pass.
Short, long, medium, no passovers. Not today.
For us also very difficult because we are faculty.
I know. Item is listed as item number 1. Where is your senior? On the way. Not today. Next.
Item number 2.
So this is peremptory. It was fixed yesterday.
Yes, ma'am.
Item 1.
Yes, ma'am.
Give the file. File the. This is not This is not a joke. Yes, what is the ground on which? Let us see. Cattle smuggling.
Madam. This is a huge matter of this border of India and Bangladesh. These things are going on.
My lord, kindly see in my petition, page number 13, my lord. I am an Indian citizen, my lord,
Yes,
and my lord, there is
because you're an Indian citizen.
One person was arrested and the remaining person they succeeded to them, they jumped and they crossed the international border and they went backward.
my lord, my name transferred from the mouth of the Koyaku statement, my lord. I have no involvement in the present instant case. My
Then they
lord,
won't arrest you. Why do you want anticipatory bail? It is only on an apprehension of arrest. And if they do arrest you, you apply for bail thereafter.
my lord, kindly consider this.
The application for anticipatory bail
My lord, kindly consider I have one problem, my lord.
is canvassed on the ground that the petitioner is an innocent villager who was nowhere involved in the attempt at cattle smuggling.
See, in this context, I will draw your lordship attention. Observation possible output division identical situation.
Likho, click it last time.
So an identical situation, honorable court division may just please to end the division of bail.
The ground that the petitioner is an innocent villager who was involved in the attempted cattle smuggling.
Full stop.
I was
Full stop paragraph. The case registered by the police comma, is still under investigation. Full stop. One Bangladeshi national has been caught. Full stop. And certain currency was seized from him. Full stop. Paragraph. The cattle had. Now, the other persons involved in the cattle smuggling had escaped escaped beyond the international border into Bangladesh. Full stop. Paragraph. This court is of the view that whether there is complicity. You're named in the FIR.
My name transferred as the FIR from the statement of the co-accused.
Full stop. The name, কি বললাম?
This court is of view.
না, কেটে দাও।
That is Mohammed Shami.
The name, the petitioner's name, named in the FIR, registered by the which police station? Jalpaiguri PS. No, Kotwali PS.
Kotwali police station, Jalpaiguri.
Jalpaiguri. Under the Foreigners Act and Section 14, Foreigners Act, Section 224 of the BNS. 224/303 in bracket 2 and 317 in bracket 2 of the BNS. Full stop. This court is of the view that the matter is still being investigated by the police, and it would be premature to grant anticipatory bail to the petitioner. Full stop. Paragraph. The application for anticipatory bail is therefore rejected. No, counsel for the applicant has relied upon a decision of a coordinate bench, division bench, in CRM 420 of 2024, dated 22nd May 2024. Full stop. It is submitted that in a similar situation, the anticipatory bail has been allowed. Full stop. This court is of the view that no two cases can be equated on facts. Full stop. And hence the granting of anticipatory bail to the petitioner at this stage would be premature. No, may frustrate the investigation itself. Anticipatory application rejected. Next. Yes, what is the charge under?
My lord, kindly come to my lord. Page 9, madam. That is the written complaint. The gist of the written complaint, my lord, it reflects that, my lord, the allegation is only, my lord, attempt to commit rape. And it has been specifically, my lord, stated in the FIR. My lord, so far the narratives of the complainant is concerned, my lord, she herself stated that, my lord, the petitioner tried to, my lord, commit rape.
So,
My lord, this
had you succeeded, then you.
no, my
Then?
lord. No, my lord. It's the only, my lord, attempt, my lord. She has precisely stated in her complaint. My lord, number 2 is that, my lord, the alleged incident took place, my lord, on 18th of December 2024. And, my lord, she prompted to, my lord, lodge this complaint on, my lord, 20 of December 2024. After, my lord, after a delay of 2 days. A concocted story, my lord. The petitioner, my lord, happens to be, my lord, the next door neighbor of the complainant. My lord, there was a long-standing, my lord, dispute between the, my lord, complainant's husband as well as, my lord, the petitioner. My lord, out of that, my lord, revenge and grudge, my lord, this concocted allegation has been labeled. She herself stated that, my lord, the petitioner tried to commit rape, having been trespassed into the house.
Complaint is sealed, huh?
Yes, I have.
My lord,
The
on the earlier occasion, my lord,
I have already translated the Bengali FIR.
Why did you go into our house?
No, that is not, not an allegation, my lord, a concocted
You didn't
story.
even go into the house.
No, my lord, I happens to be one of the next door neighbor. My lord, she took the advantage, my lord, out of that, my lord, long-standing, my lord, dispute between the husband.
What is the dispute?
My lord, there was a dispute with regard
Have
to.
you stated anything about the dispute in your application?
No, my lord, no.
There is no evidence.
The
Only when,
160 statement of the lady is there.
my lord, she is a my lord, married lady, my lord. My lord, no sexual abuse, my lord, no, my lord, aggravated, nothing has been done, my lord. Out of that, my lord, the entire, my lord, story, my lord, projected a concocted story, my lord. Only, my lord, attempt to commit rape. Nothing has been done, my lord. No sexual abuse has been done, my lord.
page?
Page 5A. I have also.
She is a married lady, my lord.
Sir, married lady, is it a ground for acquitting you?
No,
Or is it a ground for, entering the house of a, or does it entitle you to enter the house of a
my
married
lord,
lady
that
and
is
grab
the,
her
my
from
lord,
the back?
accusatory statement that has been projected in the complaint, my
So
lord.
there is prima facie case
Lord,
made out.
My lord, whatever, my lord, whether, my lord, I have, my lord, criminally trespassed into the house, I have committed the rape, my lord, that is a subject matter of trial, my lord. It will be decided in the course of, my lord, examination of the witness as well as, my lord,
Has the police arrested you till now?
my lord, until
If they
and,
wanted, they could have
my lord,
taken you into custody immediately.
my lord, until and unless, my lord, I exhaust the remedy under section 438, my lord, how could I mess up myself, my lord, surrender, my
A
lord.
warrant of arrest has been issued against this petition.
You are absconding.
Yes.
My lord, that is why, my lord, I
next
prayed
date
for
has been fixed,
anticipatory
Lord,
bail.
on 15th November 2025.
Lord,
For execution.
Allow my anticipatory bail, my lord. I will cooperate with the investigating officer, my lord. To every extent, my lord. I have not, my lord, ravished the, my lord, the victim, my lord. There is only an
So
allegation.
should we she wait until she is ravished by you? What kind of an argument, sir?
My lord, that is the statement of the, my lord, the de facto complainant, my lord.
What
That she has tried to commit rape, having been, my lord,
what
trespassed.
business did you have to enter into her house when her husband is not there, and
My lord,
that too
that
into
is
a
the
bedroom?
allegation, my lord.
That's
Apart
right.
from the, my lord,
There
the
is a
fact, nothing
prima.
has happened, my lord.
Have you explained with under what circumstances of the whole dispute of everything, personal dispute with husband in your application?
My lord, the penal section that has been attributed, these are, my lord, the section, my lord, kindly come to, my lord, the
Mr. Counsel, I asked you a
64 and
question.
62.
I
The
asked,
attachment, my lord.
I
Inscription.
asked you a question.
Lordship.
Have you mentioned any details about the past enmity between you and the husband in your application?
No, my lord, that has not been.
Then the application for anticipatory
My lord,
bail
if your lordship
is canvassed on the ground that
supplementary affidavit, my lord. Give me 1 day accommodation.
on the
my lord.
ground that the applicant has not actually the complainant has not stated that the offense of rape has occurred on her. Full stop. It is further argued that the alleged victim has unleashed a personal vendetta against the applicant in view of a long-standing rivalry between the husband and the applicant. Full stop. This court, however, notes that there are no particulars of such rivalry or dispute between the petitioner's husband, between the applicant and the victim's husband mentioned in the application for anticipatory bail. Full stop. The statement of the victim, the complaint and the statement of the victim under 164 of the CRPC, equivalent to 164 is equivalent to
Madam, 183, madam.
under section 183 of the VNSS have been considered by this court. The appellant has not been able to explain the circumstances under which he entered the house of the victim and her bedroom at 7 p.m. in the absence of the victim's husband. Full stop. In the above circumstances, given the prima facie case made out, this court is not inclined to entertain the application for anticipatory bail.
Madam, may I?
Application is rejected.
Two antecedents there.
Two,
Antecedent is there against this petition.
Antecedent.
Antecedent is there.
full stop. It is further submitted and we last sentence the There, the appellant has counsel for the PP. No, public prosecutor, the office of the public prosecutor, counsel representing the PP submits that the applicant has antecedents of criminal activity in the past for which FIRs have been registered.
Yes.
Full stop, paragraph. Having regard to the above, FIR's numbers are there with you?
Miller.
There being FIR, for which FIR,
The last portion of the
FIR number,
PSK.
No. Being Pundiwari PS case number 179 of 2024, dated 16th March 2024, and Pundiwari case number PS case number 460 of 2024, dated 23rd June 2024.
Yes, sir.
Inter alia under section 341, 326, 307, 506, 323, 325, 354, and 354 of the IPC. Full stop. In the backdrop, in view of the above, this court is not inclined to entertain the application to anticipate.
Kindly add only one line, my lord, so that not at this stage rejected, my lord. Because investigation is going on, my lord. After conclusion of investigation, my lord, I may have, my lord,
Definitely, post investigation, if there is a charge sheet filed against you,
but I could have filed a, my lord,
Then
second
there's no
application,
question.
my lord.
then
My lord, kindly add one, give me a favor, my lord. The pre-investigation
Sir,
stage, my lord.
if you make a flimsy application like this is what will be the result.
But whatever the allegation,
Application at this stage.
I'm grateful.
I'm grateful to Lordship.
Next.
Item number 4.
Yes, ma'am. This is my.
I have the statement. Yes, sir.
Yes, correct, my lord.
Wildlife protection,
Yes, one, that elephant man.
elephant.
My lord, this is the bail application of another main accused. With the information sheet.
The investigation is still on, man.
Very well. Is he cooperating in the investigation?
No, he's absconding since.
No, Milord, I am not absconding, Milord.
He's absconding.
No, Milord, I am not absconding, Milord. I am residing in Kerala.
Since
I am here.
October 2024.
And Milord, the Babu Mondal is cultivated, Babu Mondal cultivated the land and in his land where incident took place, Milord. That is my submission.
So how long are you away from West Bengal? The incident occurred in?
Incident occurred in
2024, man.
24 Milord. No,
Then you escaped to Kerala.
no, Milord. Before that, I am a day labor.
My lord,
I am-
may I
I
submit
am
one
mistaken,
document?
Milord.
Here is the
Kindly see the
statement.
LCD, Milord.
Here is the statement of the co-accused, that is whose bail order he has just now produced.
देखिए
My lord, this is the statement recorded under in terms of section 50 subsection 8, which amounts to a confession under the Wildlife Act, my lord. He has roped his brother in it. He has named his brother. I am a confession of co-accused. It is a self-inculpatory statement, my lord. It is relevant under section 30 of the Indian Evidence Act. It's a sufficient material against him. Both the brothers were equally involved.
No, since he has got bail,
My lord, he has got bail. He was in custody for a considerable period. Only he got bail only because this man was absconding, my lord. An investigation, we need to investigate him. We need to take him into custody and interrogate. It's an anticipatory bail application. He got bail after considerable custody, my lord.
That is not my fault.
land will not be in your name.
I am ready to any condition. I am ready to this. Ready to any
So at least you come and surrender before the police, then we can consider. At least if you cooperate in the investigation.
I got.
Why haven't you cooperated till now?
They did not do any
The application for anticipatory bail is canvassed is pressed on the ground that the principal accused landowner, elder brother of the petitioner, has been enlarged on bail. Full stop. The prosecution case in brief is that the petitioner and his brother had set up an electric fence around their fields, as a consequence whereof an elephant got electrocuted and died. The carcass was found in the house of the accused persons. Full stop, paragraph. The full stop, paragraph. It is argued by counsel for the petitioner that he is he's working in Kerala since after the incident as a daily laborer. Full stop, paragraph. This court having regard to the fact that the principal accused has named the applicant as a participant as one of the participants in setting up of the electric fence. Comma. Ki bola? Start sentence.
In regards to the fact that the physical accused is has named the applicant, one of the participants in setting up. of the-
As one of the participants in setting up the electric fence. Comma. And having regard to the fact and considering the fact that the applicant is absconding and has not cooperated in the investigation till now. Comma.
I am ready to cooperate, my lord.
Why haven't you cooperated till now?
My lord, I am ready because I am in Kerala for that. My lord. I am day laborer. Kindly consider any condition. my lord.
This question was
Well, any
raised before Honorable Justice
They- my lord,
Prashad,
police did
and
not-
my lord,
my lord,
his
police
lordship was
did not
issued
issue
directly
41
to
notice,
produce a
my lord.
document to that effect that he was in Kerala. Ultimately, it appeared before his lordship that submission
My
got.
police authority did not issue 41 a notice, my lord, for appearing me. I am ready. I am ready any condition.
So again 141A first you appear, then we will see.
Yes, I am ready,
Comma has not cooperated in investigation till date. Comma having regard आगे having regard केटे दाओ दुटो having regard ही केटे दाओ full stop कर दाओ दुटो sentence कर दाओ ठीक है भैया comma full stop the full stop before the earlier bench it was before the earlier bench, the applicant had indicated that he will produce evidence and documents that he is working in Kerala. There are no such documents produced today. Full stop, paragraph. In those circumstances, comma. The application for anticipatory bail is rejected at this stage. Full stop. You respond to 41A notice, then
Yes.
At this stage, full stop, the response to the response of the applicant to the notice under 41A is yet to be ascertained. Since the response of the applicant to the notice under 41A is yet to be ascertained. ঠিক আছে? এটা দিয়ে sentence full stop, disposed of. Once you respond,
Yes, I am.
then you, I made that as a condition. Then if he responds, he'll cooperate in the investigation, then you renew. That's why I said at this stage, you file again after that. Okay? Hey, take this back, please.
I for the petition, allegation under section 108 of the CNS plot, corresponding to section 306 of the Indian Penal Code. Petitioner,
Abatement to suicide.
petitioner is a brother-in-law, victim is the husband who committed suicide, principal action is the wife, and then the marriage organization on 11 and back, victim is to work in a private bank, he and the victim number, petitioner, accused number 1, is to decide together. And transfer is transfer different places. The principal actor,
There is a confessional statement, a suicide note, isn't it?
if I have not been
But suicide note is there.
Suicide note is there naming the wife primarily
My lord, actually, my lord,
and the family of the deceased.
yes,
other brother-in-law of the
this petitioner is the brother-in-law of the deceased, my lord. Prime accused, all the accused persons are named in the FIR, all the.
Have they got bail?
They are out total accused person, my lord, number is.
three principal accused to wife killer. If you lordship kindly come to the
Wife is in custody.
Rest two persons, no, only one, yes, my lord. They are taken into custody, after that,
Bail granted.
bail granted. This petitioner is still absent. This is the.
No, grant of anticipatory bail will help you in investigation. Full stop. It is submitted that, the application for anticipatory bail is canvassed from the ground that the applicant is the brother-in-law of the deceased husband who committed suicide. Full stop. The allegations in the full stop. The allegations in the suicide note, point out towards the harassment by the in-laws of the victim. Full stop. Since the principal accused wife has been arrested and was arrested and enlarged on bail. This court is the view that the applicant must be is entitled to anticipatory bail. Full stop. In the event of arrest, the applicant undertakes to cooperate in the investigation and visit the investigating officer as and when required. Full stop. He shall furnish a bond. He shall furnish surety for rupees 5,000, two sureties of rupees 5,000 each, one of whom shall be local. Full stop. Paragraph. He shall not leave the local. Full stop. The other conditions. He shall attend the trial on each day fixed by the trial court. Any other condition that may be stipulated, that may be required by the trial court against the petitioner may be specified. May be imposed on him accordingly. Full stop. Paragraph with the associate observations. Application allowed in this form. Yes, sir, 6. The petitioner was not represented yesterday.
And for question.
There is no representation of the petitioner on behalf of the petitioner today. Today, CRN 299 of 2025 shall stand dismissed.
Okay.
Number 8.
8, sir.
Section 157 to 1152, 143, 304, 35 of the BIS.
What are these sections?
137 to 143, 1152.
What are these? What is the offense?
Kidnapping, voluntary person act, snatching, and criminal act done by several persons. Two are bailable sections, two are non-bailable sections.
304 is what is non-bailable?
The non-bailable is 304 snatching and kidnapping with 143 kidnapping with intent to cause that person to be secretly and not to be confined. Now, may I go through the complaint? Complaint was lodged by one wife of Abjar said on the 23rd of January before the officer of police station, football police station, stated that in the complaint it was stated that her granddaughter, aged about 15 years, was staying outside her home, at about 9 p.m. The complaint was lodged by the grandmother, despite of his parents and father and mother living together. Now, under the instruction of Tahir the accused person came to her house, took her granddaughter in an auto. Kindly may I pause here for a second. The 8 persons, 9 persons, how can they accommodate in a single auto? They took her in auto to Dhumpur village under Kodwal police station. On the way, the accused person treated her with low at fish. Still no evidence, no medical examination was conducted. Thereafter, the accused person took her mobile phone, no evidence of mobile phone, no EMI number, no mobile number was stated in the complaint. She was brought to the accused person's home. Within a couple of hours, the victim girl was returned to her home with the help of local villagers. Now, may I state one thing, this complaint itself is contradictory. Full of I have a typed copy of the complaint. Kindly produce the complaint.
May I submit?
Yes.
My lord, victim is the star witness in this case, my lord. Now the victim has been recovered by the intervention of the local village. She was taken away. Thereafter, the local panchayat said, no, we cannot take responsibility for a minor girl. She was returned back. The intention was different, my lord. It is the intervention of the local panchayat that could save the life of this girl. Otherwise, the consequence we never know.
Just couple of hours, she was back to her home.
Couple of hours doesn't mean the action amounts to an offense, man. The duration doesn't matter.
Tahir Mia is the principal.
And she named everyone. Every petitioner she named categorically in the 150%.
How many applicants? All 8 applicants.
9 of them. All are family members, including Bhutan.
All are named in the 164 matter. An investigation is going on. Very early stage.
No 41 notice served, No 41 notice still did not served,
304, 41 is not relevant.
And moreover, if allows the prayer for bail of the other petitioner, except Tahir, the other petitioners are, they are not at all accused. They have acted upon the instruction of Tahir. He is the sole principal accused under the instruction.
What was the object of kidnapping her? Trafficking.
No, Lord. No
Yes.
intention. There was a family dispute among them.
So they will kidnap a girl.
They are all family members, including women, They have
All the more reason.
They all are staying in the same locality,
So they will kidnap a girl.
Kidnapper, this is the entirely false complaint brought by
Right.
despite of father and mother kindly appreciate, father and mother was not present in the house. They have not lost their singles. Neither their statement was recorded,
That is for investigation is on.
Yes, sir. Investigation is on. They are
Kindly
escorting
consider,
in
sir.
every raid they are free away.
Rejects the-
Police is not able to catch them. Any of them.
They are in the same
The application for anticipatory bail
Kindly reject the
I
prayer of
was-
Tahir and
I-
allow the other
officers,
petitioners,
right?
pressed
innocent,
on the ground that the accused that the applicants accused
Two are bailable offense,
are all family members and out of a family dispute had kidnapped the victim girl. Full stop. The girl was recovered at the intervention of another an intervention of a local panchayat under which the girl was kept in custody, kept away, kept in detention. Full stop. Counsel for the petitioner would argue that two of the sections are available. Full stop. The complaint was lodged by the grandmother despite the presence of the parents. Full stop. Paragraph. It is lastly argued by counsel for the petitioner that the principal accused is applicant number 1, Tahir Mian. The others were acting on the instructions of Tahir Mian. This court, learned counsel for the learned public prosecutor office has placed the statement of the victim girl before the judicial magistrate and also the complaint. Full stop. Paragraph. While it is true that a complaint, while it's true that the complaint may contain certain contradictions, the FIR, it is now well settled that an FIR is not an encyclopedia. FIR is not an encyclopedia. Full stop. Paragraph. The investigation is still on and each of the applicants are absconding. Full stop. In the above circumstances, this court is not inclined to entertain the application for anticipatory bail. Full stop. CRM so and so shall stand dismissed. Case diary is produced and returned. Here, the case diary code. Here, take this back.
Item number 9.
9, sir.
Page 9 first.
1 minute. FIR under sections?
FIR under section, my lord, 316,
Is it,
318, 79 of the bills.
what are the sections?
My lord, 300.
What are the offences?
My lord, 316 my lord, corresponding to 406 each of trust, 318 cheating and 509 my lord. My lord, page 9 my lord first.
406, 420.
420 and 509. My lord, first of all, page 9 my lord.
Yes.
My lord, the
Rag is appearing, my lord, in this case, my lord, for the state, my lord, he is moving a matter.
No problem. Carry on.
Yes, yes.
My lord, the first paragraph, my lord, the opening line, my lord, that starts with, my lord, the fact that the de facto complainant, my lord, executed an agreement on 22nd of July 2024. Lordship.
The civil dispute, right?
Absolutely civil dispute.
And more importantly, cheating and breach of trust don't go together.
It's true.
The FIR registration, the FIR itself is wrong. That FIR is liable to what? If he moves under 482, it will get caught.
Lordship.
Anyway,
It's an abuse of process of law.
the application for anticipatory bail, petitioner applies for anticipatory bail on the ground that the FIR discloses offences. FIR has been registered both under section 316 and 318, 3162 and 3184 of the BNS. Full stop. Paragraph. The dispute is with regard to return of money relating to sale of land, apart from the fact that the dispute is primarily civil in nature, is substantially civil in nature, it is now well settled that offences under 316 in bracket 2 and 318 in bracket 4 of the BNS, cannot be and are mutually exclusive. Full stop. In the above circumstances,
One interest, Lordship. The state raises objection.
obviously, the Learned Counsel for the state raises objects to the prayer for anticipatory bail. Full stop. Having regard to the facts and circumstances of the case, and having perused the case diary, this court is of the view that the petitioner has made out a case for anticipatory bail. In the event of arrest, the applicant shall be released on bail on furnishing of security. On the surety of 2 witnesses of rupees 10,000 each, one of whom should be local. Full stop. The applicant shall cooperate in the investigation and appear before the investigating officer as and when summoned. He shall not leave the station. He shall not leave station without the permission of the investigating officer. Full stop. Paragraph.
Or the jurisdictional court.
Or he shall not leave the jurisdiction of the court. No, it is or without the permission of the investigating officer or the
Or the
jurisdiction.
jurisdiction.
Full stop. CRM 312 2025 is allowed in this. Next.
Much of it.
Huh? না না কোর্ট ইনভেস্টিগেশন চলছে এখন পিএস এর কাছে
The lordship depend could be on the virtual mode.
সরি
Depend could be.
Am I audible?
yes
Am I audible?
you are audible sir
My lord, my lord, allegation on section 135 of Electricity Act of Electricity.
electricity act
What is Electricity Act, theft of electricity at my commercial place. This is the allegation.
theft of electricity all right it's a bailable section sir
Now, my lord, I have complied.
Theft of electricity is a non-bailable section. The punishment is up to 3 years. Up to 3 years, and Lordship, here the total amount of theft to the tune of rupees 6,42,000. And there is a provision for compounding. They could easily have compounded the offence.
Now, my lord, 3 things I will say. I have already complied with the notice issued by the investigating authority under section 35(3), 41A notice, CRPC. Now, my lord, second thing, if your lordship kindly peruse page internal page 19, my lord, notice was initially issued in the name of one Sanjoy Bodua. My name is Manik Bodua. Kindly see, it was amended through pen through. Sanjoy, the portion of Sanjoy has been pen through.
yes
Initially notice. This is my first point of
that is
submission.
either
Notice was
what is
initially-
second point
Well, at second point is that they have admitted at internal page 25 and 24 that they have lost all the documents in connection with the meter in dispute. They have admitted at page 24 and 25. Well, kindly
that's
have a
why
look.
you stole and you became a hooker
Well, I have not committed any theft and last thing, my commercial space, there is action from which hooking can be done. At least there's a fan or electricity line. There is no line within my commercials. They are settling the amount.
the electricity
They
matter
don't have any
bail is generally
document.
granted
But Lordship, the objection of the state may.
Definitely. Always.
Always, because a case of direct hooking.
Anyway, he'll cooperate in the investigation, don't worry. Unless he
Well,
makes attempts to compound, you better compound the offense as soon as possible by paying
Well,
out the dues.
Well,
And you avail the benefit under the Electricity Act also.
Millet, there is no prima facie case on their behalf of the state. Millet, kindly have a look at the document. They
Anyway,
have
do
admitted
whatever you want.
that
You
they have lost
cooperate in
all
the
the documents.
investigation. That's what we'll say.
Yes.
The
I will.
applicant seeks anticipatory bail on the ground that the allegation against him is of theft of electricity in a commercial place where there are no electricity lines. Full stop. Paragraph. The quantum of theft is in the region of 6,45,024. Full stop. The complaint was lodged by the WBSC DCL. Full stop. Initially against one Manik. Manik Barua, whereas a complaint was also against one Sanjay Barua, whereas the applicant is Manik Barua, who is 53 years old. This paragraph. Having regard to the fact and circumstances of the case, this court is viewed that the petitioner has made out a case for
One in
anticipatory bail.
lordship. The notice has been given to Manik Borua, not Sanjay Borua.
Well,
Page
that I
number
know, but
page number
initially
20.
complaint initially was against Sanjay Barua. No? Right. The anticipatory bail. Petitioner having regard. Full stop. The having etiquette. Having regard to etiquette. Full stop. Counsel for the state vehemently opposes the prayer for anticipatory bail. Full stop. However, having regard to the nature of the offence and the allegations in the complaint, this court is inclined to allow the prayer for anticipatory bail.
Investigation is over.
Full stop. Charge sheet filed.
Yes.
Anticipatory bail. Vehemently oppose the prayer for anticipatory bail. It is submitted. The investigation has been completed, and charge sheet has been filed. Full stop. Paragraph. Having regard to findings, inclined to allow the application to anticipatory bail on the condition that the appellant appears before the trial court when it upon the commencement of the trial. Full stop. The appellant shall not leave the jurisdiction of the court. Shall not leave the his place of shall not leave the jurisdictional area of the court without its leave. Full stop. The trial court may specify any further conditions for grant of bail. Trial court specification. The petitioner shall the further condition for bail is that the petitioner shall furnish surety of two persons of rupees 10,000 each, one of whom should be local. Any further conditions may be for bail may be specified by the trial court. The applications allowed disposed of.
Grateful, Millet.
এটা সুপ্রিম কোর্ট বারণ করেছে বেলের সময় এটা 138 কেসে টাকা জমা করে ওখানে স্ট্রিক্টলি প্রহিবিটেড বেল দেবে
But I'm praying for 1 day application.
Why, sir?
But I'm not prepared, man. 1 day.
Very well, not today. I'm very good statement. Applicant. The de facto complainant is present as well as this present as is the state. Applicant is not represented. CRM so and so shall stand dismissed.
But not I am appealing for the state. The Mahaputar is appealing, madam.
Where is he?
He is in court number 4. Moving on, madam.
Not today. Put in, sir.
Also, my
Same. Not today. That's it. Yeah.
16 and 17 and things are not today. Actually, yesterday it was for day after tomorrow. Yes, sir.
Yeah, tomorrow.
I have no idea. madam.
এটা কালকে ডে আফটার মনে হয়েছে তো কি করে রাখো তো আজকে
Yesterday it was 6, madam.
it was there yesterday. Nobody appeared. So peremptorily fix it today. Very well. Not today.
Yeah. 7.
16, 17 action.
Item number 18. Item number 18. Kumar Majumdar will apply some particular.
Who is the petitioner?
I'm going to respond.
Petitioner?
Sudipta Kumar Majumdar appeared.
Where is Mr. Majumdar? Yes. Yes, Mr. Majumdar. Unmute yourself, please.
Lordship, am I audible?
Yes, yes. Yes, you are audible, sir.
Lordship, in this case, earlier coordinate bench was pleased enough to direct us to file an reply. But I just, I humbly pray for an extension of few days to file that reply, my lord.
Time to file on prayer made by counsel for the applicant. Time to file affidavit and reply is extended by a period of 2 weeks from date. List before the next
Lordship.
available, sir.
Grateful, my lord.
Swear. Anitu. Yes, Mr. Moda.
Ready.
Both sides ready, come. No. That's all right. We adjourned it for you, sir. 13 and 14. Yeah, 13. Down, 13 down.
14.
Uh, 13, 14 দুটোই তো। Yes, sir.
Who are basically allegation of physical assault, India start and 300 should be identified. This is earlier but this is great allegation. There is 6 actually petition of allegations are one person is secretary of a organizing committee and there is a quarrel with some person who can bear the allegation of slap.
Slap is grievous hurt.
All the injury reports are simple. All the injury reports are simple.
The application for anticipatory bail is pressed to the ground that the dispute arose. Between the complainant, de facto complainant and the applicants arose. in connection with organizing a puja, local puja, full stop. It appears from the records that the injuries sustained by the victims are simple in nature. There were slaps and scuffling between the petitioner, between the parties. Full stop. In the above circumstances, this court is the view that the applicants have in the above circumstances. Counsel for the state opposes the prayer for anticipatory bail. Paragraph. This court is, however, of the view that the applicants have made out a case for anticipatory bail in the event of arrest. For anticipatory bail, in the event of arrest, the applicant shall be enlarged on bail upon furnishing surety of two persons for ₹500 each. No, 1,000 each. Full stop. One of whom should be local. Full stop. They shall cooperate in the investigation and attend the and report to the investigating officer as and when summoned. Full stop. Paragraph. The application is allowed and dismissed. Next, please. Calcutta.
In this case, Madam, I'm saying allegation contrament was not required for me, Madam. My implication on the case is a statement of co-participation. Statement of co-participation, except statement of co-participation, no other material. If you statement of co-participation not lying this piece of evidence, that principal accused found in counsel required.
So that is in the case of a trial. Conviction can be based on accused, but
on this regard,
my view is different. You know my view, because that will be determined in court. Absolutely. That is the case where the trial had conviction had occurred on the basis of the statement of co-accused. Here it is still in the preliminary stage of investigation. Your role has to be determined and commercial quantity. Not. Counsel for the applicant does not wish to press. Now, on instruction submits that his client does not wish to press the application for anticipatory bail. CRM 314 of 2025 will stand dismissed as not pressed. Sure.
video.